Good morning and welcome back to EU-Jill after Brexit. My name is Amélie Lemoine and in today's episode I will introduce you the subjects of the impact of the Brexit on the Common European Asylum System and the Dublin II regulation. We have the pleasure to welcome Gerardo Medrano III, expert on the Common European Asylum System, and Mathilde Haas, expert on Dublin II regulation. Firstly, a quick reminder on what is the Common European Asylum System and the Dublin II regulation. The Common European Asylum System that will from on be referred as to the CEAS is a set of legislative texts setting standards and procedures common to the member states of the European Union in the area of asylum and migration in order to offer applicants and beneficiaries a unique status and an equal degree of protection throughout the territory of the Union. The CEAS consists in 5 main texts, which are the Qualification Directive revised, the revised Procedure Directive, the revised Qualification Directive, the Dublin Regulation revised, which is known as the Dublin III Regulation, and the Eurodac revised regulation. The Dublin II Regulation is a key legislation of the CEAS, which regulates what country will be responsible for the application to an international protection. So, following that, what is the state of the UK's participation in the CEAS?
Yes. Well, thank you for this question. As we know, the obligations of the United Kingdom currently are the revised Dublin III and the revised Eurodac regulations. The revised Eurodac regulations establishes an EU asylum fingerprint database, my apologies, when someone applies for asylum. No matter where they are in the EU, their fingerprints are transmitted to the Eurodac central system. The UK opted into the first rounds of CEAS directives in 2004, but in 2011 decided to discontinue its participation in all fields, but that of Dublin III and the Eurodac regulation. Since Brexit, the United Kingdom, during its 11th month transition period, will still maintain a relationship with most obligations, assumed under the first CEAS rounds, plus that of the Dublin III and the Eurodac regulations. It will only be on exit day, December 31st, 2020, that all obligations cease.
Okay, thank you. Could you do an overview of the issues relating to the CEAS that the UK will have to face in the wake of Brexit?
Of course. So the first issue is a potential loss of protection for asylum seekers that are provided by the directives of the Common European Asylum System. This loss will have to be balanced by the UK with the introduction of domestic legislation that will have to be in compliance with the country's international obligation under the 1951 Convention on the Status of Refugees. Another important issue is the management of the influx of migrants and asylum seekers in the UK. In the absence of continued cooperation between the EU and the UK in the Dublin III framework, the UK risks losing access to the Eurodac database, which means that the country could face an increased influx of asylum seekers in the country that the UK would then be unable to trace back and send back to another EU country. Seeing as the UK views asylum seekers rather negatively, if this situation were to happen, the UK could take measures to quash the influx of migrants, and that could potentially lead to a breach of the principle of non-refoulement that is central to both international refugee law and in European law as well.
Okay, thank you. This issue indeed seems urgent to settle. Can you tell us what is the next for the relationship of the UK and the EU in this field?
Yes. So even if there is a deal or no deal situation, the United Kingdom has in place a system until the end of the implementation period so that applicants could be assured that there will be no legal vacuum. In lieu of the Dublin III regulation, there is draft legislation acting as a statutory instrument. It's called the Immigration, Nationality and Asylum EU Exit Regulations of 2019. This national legislation, while is argued to be less extensive by some, provides a legal blanket for those. The 50 amendments in the statutory instruments are simply holding measures until Parliament passes and approves new and autonomous legislation.
Yes, we know both parties wish to continue cooperation in this field. However, we know nothing more about the specific of this potential continued cooperation. For the case of the Dublin III regulation, there are several forms of cooperation that could be chosen. For example, a good option would be something along an agreement along the lines of what the EU has with associated countries such as Norway or Switzerland. This would, the UK's participation in the Dublin regulation would then virtually remain the same, but they would lose their voting powers in regard to the regulation as well as their influence. Another good option could be a selective cooperation. This would mean that the UK could choose which part of the Dublin regulation they would like to stay bound to and just completely opt out of the rest of the regulation. This could potentially be the case for provision on unaccompanied minors, for example. In any case, now for what is really going to happen, we'll have to wait and see where the negotiations will lead.
Indeed, we will. That's all the time we have today for this subject. Thank you both for your expertise on this subject. Thank you for watching icl-ucl after Brexit. I hope you enjoyed today's episode. And if you want to learn more about the impact of the Brexit, you can find other videos on your YouTube channel. Thank you.
Thank you.